please.
Eric Peterson, Your Honor, Spencer Fang for the debtor in possession. I'm here with Zach Farley, who is also counsel for the debtor in possession.
Good morning to you both.
Good morning, Your Honor. Carol Vichek on behalf of the U.S. Trustee.
Good morning.
Brian Huckett on behalf of Sterling Commercial Credit. I'd also like to introduce the court to Ken Ottaviano from Blank Rome, also on behalf of Sterling. Thank you.
Good morning to you both.
Good morning, Your Honor. Aaron Edelman of Armstrong Teasdale on behalf of the Stocking Horse Fitter Allied Medical LLC. Also appearing remotely today is my co-counsel Scott Davidson at King & Spalding.
Hello. Any other appearances? Mr. Davidson, would you like to enter your appearance and make sure your audio is working?
Yes, thank you, Your Honor. Scott Davidson from King & Spalding, counsel for the Stocking Horse Fitter Allied Medical LLC. Can you hear me okay?
I can. Thank you. Just a reminder to everyone that the audio is our official court record, so whether you're in the courtroom or on the WebEx, please make sure to introduce yourself before speaking. All right, Mr. Peterson, we have second day matters on today. What order would you like to take these in?
Your Honor, we filed an agenda. We can follow that order, or it's a slight variance from the court's order that I've seen here printed out this morning. Either way is fine. We're comfortable.
Oh, okay. I didn't notice any differences. Why don't we use the court calendar?
Sure.
And if as we go along, if you conclude that something needs to be done in a different order, we'll call an audible.
That works.
All right.
So, Your Honor, I'll just give you a brief update. Since the last hearing, Allied has, as you know, with the interim order, continued to operate. They have good cash balances. They're running ahead of budget, and they've been able to satisfy orders and meet customer demands. There are, of course, issues that always arise when one has a bankruptcy proceeding, and we're dealing with those. Employee retention is something we have to work hard on, and we continue to work on it, but we're still in good shape and performing as a debtor in possession. Ravinia Capital has continued its efforts that started pre-petition to market and has been in direct communication with a number of potential bidders. We'll see how many actually come to fruition, but thanks to their outreach and their efforts up to this point, we think we're in a good position to get to a sale, hopefully in the near term, preferably in June. So that's kind of where the debtor stands right now. We have a series of things up. We can take them in any order you like. We can follow the agenda that the court has set out, and we can answer any questions the court may have.
Sure. Did anyone else have any introductory remarks before we jump into the agenda? All right. Hearing none. Shall we start with the Spencer Fane application?
Sure. Mr. Farley is going to handle the employment
Very good.
application.
Very good.
Good morning, Zach Farley for the debtor in possession. Your Honor, we have 3 retention applications up this morning at dockets 13, 14, and 15. If it's all right with Your Honor, I'd like to take these up together and address any matters specific to the applications as they arise.
Sure.
These were served on May 8th, the petition date, and the certificate of service is at docket 38. The notice of hearing for today is at docket 75. We've not received any indications of objections, whether formal or informal. Your Honor, we did file a first state declaration of Akash Amin, who is the president of the debtor, and if called to testify, Mr. Amin would testify that these professionals are necessary. And just to recap for Your Honor, the professionals we're talking about here are Spencer Fane as General Bankruptcy Counsel, Morris Anderson as the financial advisor, and Ravinia Capital as the investment banker. And so Mr. Amin would testify that these are very qualified professionals. Their services are necessary for this bankruptcy to shepherd the debtor through this proposed sale process and consummate that process and clean up all the other items that will need to be addressed in a plan and bring this to a close. Mr. Amin would also testify that these professionals are disinterested and that the terms of their retention, including compensation, are reasonable under the circumstances, and that under the circumstances, these professionals and the terms upon which they are proposed to be retained, it's in the best interest of the estate and creditors to retain these professionals. Your Honor, there is one item I want to address, and that's with respect to the Morris Anderson retention application. My recollection is that Your Honor had a question at the first day hearing, or somebody had a comment at the first day hearing about the indemnification language contained in the Morris Anderson engagement letter.
Right, that was me.
Memory serves me correct. All right, that's good. That's a good start. So my recollection was that the indemnification language was problematic, potentially because of the timing of which the period would cover, including pre-petition matters. Am I also correct on that?
Well, my main concern was approving the indemnification on effectively 1 day's notice at the interim hearing. I typically see limited objections from the U.S. trustee to indemnification language, and often there's some rather standardized language that gets worked into orders that that essentially says indemnification is not self-effectuating, but you need to come to court, you need to demonstrate the basis for indemnification, that sort of thing. I don't know, Ms. Richek, if you want to be heard on that issue in the context of these two applications, or if your office is satisfied with the indemnification language as drafted, or somewhere in between.
Well, Your Honor, we would prefer that the standard language be included in the proposed order. Yes, we would.
Okay. Is there any objection to including the what I will call the standard indemnification paragraphs in the orders for Morris Anderson and Ravinia Capital here?
No, Your Honor. We would just like to see what that proposed language would be, and I'm confident we can work that out and not have an issue with it.
I think that'd be good. I'll leave it to the two of you and your teams and representatives from Morris Anderson and Ravinia to work that out. But I think I don't consider it to be burdensome for a professional, but it does, I think, give everyone comfort that everything's being done out in the open and everybody knows what the rules are.
Very good.
Okay.
I'll be happy to provide that.
Okay. Very good.
Your Honor, that was the only matter that I wanted to highlight. Happy to answer any other questions that Your Honor might have with respect to these three applications.
I did. The other thing that I had flagged at the interim hearing was Ravinia Capital's retention under Section 328A. In the proposed order that your office sent in yesterday, I think it was, I didn't see any mention of that one way or the other. And similarly, when I see 328 retention, I typically see from the U.S. trustee language that while everyone else is bound by the not fairly contemplated, what's the language from 328A? You know what I mean? Everyone else is bound by that. The U.S. trustee can object and raise a reasonableness objection to the fees. Again, Ms. Richek, I don't know if where you are on that issue in connection with the Ravinia, particularly the success fee for Ravinia.
Yes, Your Honor. We'd like to review it. I didn't receive any proposed orders yesterday, so perhaps we'll take a look at that and work with counsel for the debtors.
My understanding is that the proposed orders that were sent in yesterday were the same orders that were proposed at the interim. They were just proposed to be final. But having said that, we will certainly work with the UST's office to come to an agreement on language that will work on that point.
Okay. I think that'd be helpful.
Yeah.
All right. Thank you, Your Honor.
Certainly. Okay. I didn't have any other questions about the three retention applications. Would anyone else like to be heard on numbers 13, 14, and 15? All right, Mr. Farley, then I will grant the Spencer Fain application on a final basis. I'll grant the Morris Anderson application on a final basis, subject to your working out indemnity language with the U.S. trustee. And I'll grant the Ravinia Capital application on a final basis, subject to your working out language with the U.S. trustee about indemnity and 328A.
Very good. Thank you, Your Honor.
Where shall we go next, Mr. Peterson?
Okay. Good morning again, Your Honor. Eric Peterson, Spencer Fain for the debtor in possession. The next item on the court's calendar is the motion for DIP financing. The debtor's motion for DIP financing, granting liens and security interests, and authorizing the use of cash collateral was granted on an interim basis on May 8th, and no formal or informal objections to the entry of the final order have been filed or otherwise communicated to the debtor. A proposed order has been uploaded to the court, and the modifications are limited to alteration from to an interim to a final order, and includes some features that were not part of the interim that are in the final, but were nonetheless disclosed in the motion, and we discussed those a little bit last time. As a housekeeping matter, and we're operating on the assumption, but I should probably state it so it's clear for the record, and if it's not, we would like to ensure that Mr. Amin's declaration is admitted evidence for purposes of these hearings as it was in the interim hearings.
That's a good point, and we discussed Mr. Amin's declaration just now in connection with the retention applications. I didn't offer anyone the opportunity to cross-examine him on those points, but let's go broader. Let's see if anyone wants to cross-examine Mr. Amin on anything in his first day declaration. Hearing none, I'll admit the declaration
Thank you,
to the extent it's not already in the record from the initial hearing.
Thank you, Your Honor. At this point in the proceedings, all creditors have been given notice of these proceedings, and all creditors who do or would appear on the top 20 list have received hard copies of all the motions, including this one. The debtor has also posted all the motions and all the proposed orders to the Streta website, which has also been advertised and provided in notices to each of the creditors in case they wanted to review documents on that website. The proposed final order has also been uploaded to Streta, consistent with that practice. Pursuant to the motion, the debtor seeks authority to obtain a post-petition credit facility of up to $4 million. Pursuant to the credit facility, all pre-petition indebtedness has, per the interim order, been rolled up into a single post-petition advance. That was with the court's approval. Under the credit facility, Sterling is entitled to security interest in and to substantially all the debtor's owned and after-acquired property. Insofar as Sterling was the debtor's senior secured pre-petition lender, it had, prior to case commencement, a security interest in substantially all that collateral previously. There are one or two discrete items of equipment that constitute security for equipment leases, and there have been UCCs filed. Those are unaffected. To further secure the expanded credit line the debtor acquires post-petition, the DIP facility affords Sterling a super priority administrative expense claim, in this case, senior to all other administrative expense claims. And upon a final approval, Sterling will be entitled to additional relief. Those include a $350,000 commitment fee. The commitment fee, while high, is a proportionally smaller commitment fee than was available to the debtor in the only other credit facility that was offered for these proceedings. That was a $250,000 commitment fee, but only for 45 days and only for $1.5 million. So this is a far superior credit facility, and as we set forth at the prior hearings, this is the only credit facility we were able to find other than the more expensive one. No, we contacted dozens, and I've read a series of names off in the prior hearings of outfits that we contacted for financing, and none would even so much as submit a proposal. The credit facility is too small, due diligence is too expensive, and there are issues, obviously, with the debtor's operations, having issued WARN Act notices in December when we thought we were headed into liquidation. Interest on the DIP facility runs at 14% or more. It's prime plus 6.5%, and as set forth in the facility, and as set forth above and previously in these proceedings, we have received no objection, no input, no comment, informal, formal, or otherwise, from any creditor who'd received notice. We've discussed the credit facility with the U.S. Trustee's Office. I don't believe they have any objections either, and we've tried to work diligently and stay in communication with them on any issues they may have. On the basis of that, and on the basis of the Amin Declaration, we'd ask for a final order to be entered in the form that was proposed and submitted to the court yesterday, approving the credit facility, unless the court has questions or comments that we can address for you.
Okay, does anyone wish to be heard on the DIP motion? All right, Mr. Peterson, I reviewed the proposed order that came in yesterday. There were a couple of, I think, typographical errors that we'll address. I don't mean to cause any trouble there by pointing that out. The only substantive issue that I saw was the one that we discussed at the initial hearing about the challenge period. And Mr. Ottaviano, I did have a discussion with your colleague about having a 45-day challenge period, but the opportunity for you to argue for a shorter one when we get to this point. So it's certainly appropriate for the lender to argue for a shorter one. Under the circumstances, without a creditors committee, I would prefer to see that 45-day period remain. I thought that the lender might trade off multiple issues in exchange for cutting a deal with the committee. There is no committee to cut a deal with. I think it's rather unlikely that any creditor will bear the expense to mount a challenge to the liens, and I say that not even knowing anything about the liens or perfection issues. But I'd like to hear from the lender about its position on the challenge period, 30 days versus 45 days.
Sure. And if I may, Judge, I should have highlighted that. As we understood it, and maybe we misunderstood it, the idea of the extended challenge period was to enable the committee to mount a challenge, and because there was no committee, that was the rationale. But I understand the court's point, and I'll defer to the lender to.
Thank you.
Good morning, Your Honor. Kenneth Ottaviano, Blank Rome, on behalf of Sterling. We're fine with the 45 days, Judge. We'll agree.
That makes it easy. All right. Thank you. Appreciate your flexibility. That was the only question that I had about the proposed order. It appears that there's no objection from anyone else. So I will grant the DIP motion on a final basis with that 45-day challenge period. I'll find that notice was appropriate and sufficient under the circumstances to the extent of the information available to me about who the creditors are and that sort of thing. And the debtor's met its burden to establish that it's unable to obtain unsecured credit as an administrative expense. I'll make the good faith finding under Section 364E. And so therefore that motion will be granted on a final basis.
Thank you, Your Honor. Your Honor, the next item on the court's calendar is it's a cash management motion.
Cash management.
Motion for interim final orders. I believe that's right.
Yes, cash management is next. Docket number 5.
Number 5, right. Your Honor, the cash management motion was filed as a first-day motion, and it has been granted on an interim basis. The debtor has always banked at Enterprise, which is an approved U.S. trustee financial institution. And so we didn't have to necessarily change banks. The debtor does, however, not want to disrupt its operations by changing accounts because there's a lot of payments that come in and out of these accounts. And so we are in the practice currently with, I think, the U.S. trustee's approval of marking all of our outgoing payments, with debtor in possession stamps and things of that sort. Other than that, we would like to maintain our same business forms. And this is strictly because we don't want to disrupt operations, create administrative headaches, or interfere with incoming funds. And so those disruptions are easily avoided, especially since we're at an approved institution, that we just continue to maintain our accounts as long as, and we've communicated to Enterprise Bank, and they are identified internally at the bank as debtor in possession accounts. They should be fully collateralized at this point as well. And so on that basis, we would ask for approval of the cash management motion. The ins and outs of how that cash management system works are set forth in the motion. Like all other papers, notice has been given to creditors, and hard copies of the motion have been served on all of the parties necessary under the rules. And we therefore would ask for a final order approving the cash management motion, which is docket number 5.
Anyone wish to be heard on the cash management motion? Very well. I will grant the cash management motion on a final basis.
Thank you, Your Honor. All right, the next item on the court's calendar is pre-petition wages. And Your Honor, there's been no opposition. Service has been made on all the creditors and parties in interest as required pursuant to the rules. And the pre-petition wages, I think, are self-explanatory in that we require the need of ongoing employee activity, and not paying them is a good way to ensure we don't have that. We are working within the limitations and caps set forth in the code. And we are, I think this motion is necessary in order to maintain our employees, to maintain our staff. It's a challenging period, and bankruptcy is bewildering for them. And so I think this is just a common sense motion that we would ask the court to approve.
All right. Anyone wish to be heard on the motion for pre-petition wages? Nothing? I will grant that motion on a final basis.
Okay. The next motion we have, Your Honor, is, I believe, the critical vendors motion, which, yeah, that's right. The critical vendors motion, which is docket number 10. As with all the motions already discussed, the debtor's critical vendor motion was granted on an interim basis, and we've received no formal or informal objections to entry of a final order. We note separately for two reasons this fact. First, the court at the first day hearing, the court asked at the first day hearing that the proposed final order be modified to include additional debtor protections and obligations on critical vendors, namely to ensure that they continue to provide goods and services, and if they don't, that we can go back and try to recapture some of the funds. Those items have been inserted into the revised order. It's been submitted to the court.
I saw that. Thank you.
And a copy of that order is, like all the other orders, published as well on our Stretto website. There is an additional issue that we would like to bring to the court's attention. We're not asking for any action on it today, but as explained in the first day hearings, the debtor was very deliberate in selecting vendors for critical vendor treatment. And part of that analysis was whether a vendor was likely to stop servicing the debtor without payment. Since the last hearing, the debtors learned of some vendors it expected to continue service who are not on the critical vendor list, who are now threatening to stop. We don't know where that will go, and we're continuing those discussions. Those creditors relate to transport issues. It is possible that we would have to come back in on a second critical vendor issue, but we're not at that point yet. I just wanted to alert the court to that fact.
Okay, that's helpful. As you know, there's a dance that goes on with these things, and
right.
Sometimes critical vendor orders encourage people to try to become critical vendors, and that's not really the point, but it's the reality. So
Yeah.
I trust that you and your team will do your best to bring them in line, and if not, we'll see where it goes.
We will. And so on that basis, and based on the facts set forth in Mr. Amin's declaration, we would ask that a final order be entered on the debtor's critical vendor motion, which is ECF 10.
Anyone wish to be heard on the critical vendor motion? All right, Mr. Peterson. As I understood the proposed final order, it included a $150,000 cap, which is the same number in the interim order. The motion asked for $260. Are you sticking with $150, the interim number, or are you requesting $260 in authority?
Let me check. Oh, okay. Yeah, the 150 was what we needed for the interim period. I think 260 is the total.
260. Okay, that was my guess, and that's what's in the motion, so everybody's been noticed about that.
Yeah.
We'll make that tweak. No need to resubmit a new order on that one.
Very good. Thank you, Your Honor.
All right, so critical vendor granted on a final basis with authority for $260,000.
Thank you, Your Honor. The next item on the court's calendar this morning is the entry of a final order on the motion to continue utility service and provide adequate assurance. Consistent with that motion, the debtor has asked for authority and will ask for authority to set aside deposits of approximately $32,000 for utility providers, and it also preserves the right of those providers to come in if they think that that's insufficient to seek more. We have done that. We haven't received any objection to this motion. We haven't received any communications at all, so far as I'm aware. We did receive a note or a letter that looked like a pre-printed form routine, but no follow-up communication from the utility provider. So they are aware of the ongoing case. They're aware of the order that's been entered to date, and they're on notice that if they would like to change their security status and adequate protection, that they can come into court and do that. So on that basis, and because there's no objection, we would ask that a final order be entered on the utilities motion, which is docket number, I believe it's 9.
I think it is 9. Anyone wish to be heard on the utility motion? All right, I'll grant that on a final basis. I think we have insurance next, docket 8.
That's right. Docket number 8 is the debtor's insurance motion. The debtor maintains a wide array of insurance coverages ranging from cybersecurity to D&O policies, premises liability, workers' compensation, and a host of other items. Those are detailed in the insurance motion. All of those insurances are critical to the debtor maintaining ongoing operations, and I know are particularly important to the U.S. Trustee's Office. The insurance motion asks for authority to continue to pay those on a timely basis so that we don't have any insurance interruption. There's been no objection to that motion, whether formal or informal, and we would ask that a final order be entered approving the insurance motion.
All right, would anyone like to be heard on the insurance motion? Hearing nothing, I will grant the insurance motion on a final basis.
Okay. And the next motion, which is docket number 6, is the tax motion. Pursuant to the tax motion, the debtor asks for authority to continue to pay taxes, including taxes that were withheld from employee paychecks, taxes in the nature of trust fund taxes for which there could be liability. Also, some of these taxes may be priority in nature. We would like to maintain, we'd be current on our taxes, so we think it would be unnecessary and distracting to have to deal with unpaid taxes, and we would therefore ask that that the tax motion be granted, that the debtor be authorized to continue to pay its pre-petition taxes, including trust fund taxes. As with the other motions, there's been no objection, whether formal or informal, and we would ask that an order of granting the tax motion be approved on a final basis, which I believe is docket number 6.
All right, does anybody wish to be heard on the tax motion? No one does. I will grant the tax motion on a final basis.
Okay. At this point, I'm going to turn it over to Mr. Farley to bring up the 2 sale motions and bid procedures issues.
Very good. Thank you.
Good morning, Your Honor. Zach Farley, Spencer Fain for the debtor in possession. Your Honor, on the petition date, we filed 2 sale motions that each of which requested a variety of relief. I think they can be characterized as requesting 2 things. Number 1, requesting approval of sale procedures, and number 2, requesting the approval of the sale. And here today, we're requesting approval of the sale procedures. And if it's okay with Your Honor, I'd like to take up the motions together. The sale procedures are substantially similar, and to the extent there are any differences, I'll highlight those and we can talk about those. But
I agree. Let's take them up together.
The sale motions were noticed out on the petition date. That's at docket 38. Notice of hearing was mailed out and provided. That's at docket 75. We haven't received any formal or informal objections to the sale procedures. We also filed a declaration in support of these motions. Thomas Goldblatt, the investment banker, that's attached to each of the motions at docket 25 and 26. I'd like to offer a proffer based on that, and would offer the declaration into evidence in support of these motions.
Okay. Would anyone like to cross-examine Mr. Goldblatt? All right, I'll accept the declarations into evidence.
So, Your Honor, with respect to the sale procedures, there are about 6 items that we're requesting relief for: bid procedures, the designation of a stalking horse, approving stalking horse protections, scheduling an auction and sale hearing, approving the form and manner of the notice of sale and auction and sale hearing, and then the approval of assumption and assignment procedures for executory contracts, and then the notice of that process. So, Your Honor, taking the first item, the bid procedures, include what we believe are fairly standard and customary procedures for a sale of this kind, where you have a stalking horse, you have additional folks come in, kick the tires, decide if they want to overbid, and then have an auction if there's sufficient interest. And so we propose to establish a bid deadline, requirements to be a qualified bidder, the approval of a stalking horse, which I'll get to in a minute, setting an auction if necessary, and then having a sale hearing to approve that. Now, Your Honor, I think one of the things that we probably need to address here at the top is we recognize that this is a compressed timeline, and we believe that that is because of really 2 things. This is this process is coming at the tail end of a larger sale and marketing process that began really almost a year ago, and in December was looking like liquidation. Then it looked like we were going to be able to do a going concern sale, and several months of negotiation and sale and marketing, the investment banker accruing interest, having folks look at the data room, several folks signing NDAs, coming to visit the facilities, and do a decent amount of due diligence, and then taking that and narrowing that pool to just a few potential buyers, and then identifying a highest and best offer at that time with the stalking horse purchaser. And so we do believe that a lot of this work has been done on the front end before the bankruptcy, and so that's one of the reasons or justifications for a compressed timeline. One of the other reasons is we do have deadlines, milestones with the stalking horse. We have deadlines and milestones with the dip lender. Again, this is a dip lender that came in and really provided a bridge for us to be able to be here, which we're certainly grateful for. And we have a stalking horse that's here that allows us to have this process and really try to maximize the value of the state assets. And those are all really great things, but there is a cost to that. They want to see this process move swiftly because it leads to the third justification. This is a melting ice cube. Unfortunately, we do have the natural anxiety of employees wondering if they're going to have a job tomorrow. And there's other complexities and issues there, but the going concern value over time is only going to erode, and we do have a melting ice cube, so we'd like to get this sold to maximize the value. And in my experience, and I think others here, these types of deals don't get better with time. And so we would propose that those are the justifications for why we have proposed this compressed or expedited timeline. And we can get into the exact dates here later, but I wanted to mention that at the top. So if called, Mr. Goldblatt would testify that there was an extensive pre-petition sale and marketing effort that's contained in his affidavit or in his declaration. He would testify that these assets have been exposed to the market and the market has spoken. We are at the tail end of the process, and it justifies having a streamlined process now here in bankruptcy before we ask for approval of a sale. Mr. Goldblatt would testify that the timeline is reasonable and appropriate under the circumstances for the reasons that I just mentioned, the justifications. He would testify that this process and these procedures are designed really to maximize the value of the assets under the circumstances, and would testify that the bid procedures are fair and reasonable and appropriate under the circumstances. So, Your Honor, that deals with the bid procedures. I'm happy to discuss those now with you, or we can take those up at the end if you have any questions.
Why don't we do the full proffer? I know I offered people a chance to cross-examine and they declined, but if we're going to get into specific details, let's do the full proffer. I'll offer them another chance to cross-examination, which they will probably decline, and then we can get into some of the details.
Very good. Your Honor, the next item is the designation of the stalking horse purchaser, Allied Medical LLC. I would mention here at the top that Allied Medical LLC is not an affiliate or insider of the debtor. There's not a connection. They're disinterested, so to speak, vis-a-vis the debtor. Mr. Goldblatt would testify that the stalking horse purchaser was selected after considering several other options, and after considering all those options over many weeks of negotiations, it was determined in consultation with the debtor and the financial advisor that this was the highest and best offer that they were able to negotiate under the circumstances. And really, this presents an offer that is in the best interest of the estate. Of course, subject to overbids and an auction if we get to that point. Mr. Goldblatt would testify that the terms of the stalking horse APA and the stalking horse protections, which I'll get to in a minute, those were negotiated in good faith and at arm's length. And they would testify that Mr. Goldblatt would testify that having a stalking horse purchaser provides the debtor with the opportunity to sell the assets and preserve going concern value, which is really important here. And this is probably saved for our final sale hearing, but there are a number of considerations and issues if this goes to a liquidation, both with respect to St. Louis and with respect to New York, where having a going concern sale is valuable. And this offers us that option and that opportunity. But it also offers us the opportunity to have a baseline by which other folks can come in and overbid if they'd like. So, Your Honor, the next item is the stalking horse protections. The first proposed protection is an expense reimbursement. I want to highlight here that we don't have a breakup fee. It's just an expense reimbursement for actual documented expenses that are reasonable and necessary, and the magic language on that is contained in the asset purchase agreement. In my view, Your Honor, this is atypical, but in a positive way for the estate. I think that it's very common to see breakup fees in addition to expense reimbursements. But here we just have the expense reimbursement. Now, the expense reimbursement is capped at 3.5% of the initial purchase price. And we believe that this is in line with total breakup fee / expense reimbursements that you see in other cases, which 3.5% seems to be somewhat of a magic number across jurisdictions. The expense reimbursement is proposed to have super priority expense treatment. Now, when you look at the APA that we negotiated, it seems very unlikely, and I'm trying to figure out a situation where this would come to pass, but the expense reimbursement is not triggered unless and until an alternative transaction is consummated, and it is anticipated or really, we think, required that the expense reimbursement will be paid out of the sale proceeds at the closing of an alternative transaction. So something very strange would have to happen whereby those sale proceeds do not make it to the stalking horse purchaser. But if that were to happen, in that unlikely event, then the stalking horse purchaser would have a super priority claim for that amount. And if called to testify, Mr. Goldblatt would testify that, well, I guess let me back up. The expense reimbursements have two components. One is the reimbursement of legal fees for the stalking horse purchaser, capped at 1%, and then fees and expenses for due diligence reports, and that's capped at 2.5%. And those reports are to be made available for all in the data room. And so on
that's a question I had for you, so thank you for clarifying that.
Yes, and so on that point, with respect to that 2.5%, those fees expended really are fees well spent for everyone, because it provides more information for other folks to come in, and we really see that as a benefit to the estate, because it theoretically will, the more information the better, because it lowers the barriers to entry for other folks to come in and decide if they'd like to participate in this process. And we think that's a good thing, because the more interest and participation should number one, provide an auction, and number two, provide a robust auction. And so we believe that those fees that are expended are really a benefit to the estate, and Mr. Goldblatt would testify that to those things, that those expenses are important to provide information to others, and would support a finding that there's a benefit to the estate to support a super priority claim. Your Honor, the other stalking horse protection is the initial and subsequent overbids. These are proposed at 5.5% and 1.9% respectively off of the initial purchase price. And I'll give you some numbers here in a second, but we do believe that these percentages are within at least the ballpark of what has been approved for market in the Eastern District of Missouri, looking at the Briggs and Stratton case, the Peabody case, and then another case that some folks may not know, but it's 3I AVI LLC, and that's in the Eastern District of Missouri. We do believe that the initial and subsequent overbid percentages in relation to the purchase price are market based on those cases and outside of this district, as cited in our sale motions. Now, when we calculate those numbers, that would provide, and I should also mention that in the proposed order that we uploaded to the court, we did add numbers for these bid increments. And we have the percentages still there, but we've added numbers now. And those numbers for New York, the initial bid minimum is $200,000. The subsequent bid amounts will then be $70,000. For St. Louis, the initial bid amount will be $280,000, and the subsequent bid amount will be $100,000. And Your Honor, I can walk the court through how these are calculated. Again, they're percentages off of a defined term in the asset purchase agreement, which is the initial stocking horse purchase price. And the initial stocking horse purchase price is defined as a cash amount plus an amount equal to 95% of the aggregate total of receivables less zero-rated receivables as of the closing date. And so that last part requires an estimation, and based on our estimation plus the cash amounts, that's how we've arrived at the bid increment in terms of dollars. And
that makes sense.
We've consulted with the stocking horse purchaser on that, and I believe that they're in agreement that those are accurate numbers from their perspective. So that's the bid subsequent and initial overbid amounts that are proposed. Your Honor, the final bid protection is credit bidding by the stocking horse for the expense reimbursement amount. Now, as of this date, I don't have that number of how that expense reimbursement is going to be calculated, because the asset purchase agreement takes into consideration that the debtor has also expended resources in getting these due diligence reports, these specific ones, and so the asset purchase agreement contemplates that there will be basically a netting out of those amounts expended by the debtor and the stocking horse purchaser. And so when those are netted out, that is what becomes the expense reimbursement for the stocking horse purchaser. We've had some discussions about getting that number finalized, and we'll do so before the auction. I don't know that it's necessary that we need to have that resolved today or tomorrow, but we'll just need to have it resolved if and when we get to the situation of that being paid, of that
Sure.
needing to be paid.
Sure, I agree. I don't think we need to pin that number down today.
But, Your Honor, if Mr. Goldblatt were called to testify, he would testify that all of these terms, all of these protections have been negotiated at arm's length. They're necessary to ensure that the stocking horse would act as a stocking horse, would stick its neck out there with a baseline bid to have others come in and overbid after they've spent all of this money and resources and time getting to this point. And Mr. Goldblatt would also testify that this was a material inducement to secure the stocking horse based on the negotiations that we had over several weeks. This was a highly negotiated deal that took really, I haven't done the math, but I think it did take probably about 2 months to finally negotiate. But Mr. Goldblatt would also testify that these protections, while there is a cost associated with them, is a net value to the estate in having a stocking horse and having this process, because without these protections, we wouldn't have that process. Mr. Goldblatt would testify that these protections are fair, reasonable, and appropriate under the circumstances. And so, Your Honor, that addresses the bid protections, the proposed bid protections. Number 4 is scheduling an auction and a sale hearing. I mentioned at the top that we recognize these are streamlined and expedited, but we do believe they are necessary. While they're expedited and streamlined, we also believe that it still allows for people to have the time to become aware of this process, many of which are already aware because of early pre-petition marketing efforts. Now that they know that we're going to have an official process, I think it really crystallizes who's going to participate and who's not. But they have time to participate and be heard if they choose to do so. And, Your Honor, we have proposed dates for the auction if that becomes necessary. St. Louis would be proposed to be auctioned June 20th, and New York June 21st, and then with a turnaround sale hearing to approve highest and best offers on June 30th. And of course, there are some other dates between there, including objection deadlines, and I'm happy to run through those now, Your Honor, if you'd like. We did provide them in the proposed order. I believe they're consistent with what was proposed initially.
I'm looking at the summary of pages 8 and 9 of the New York motion. Are there any substantial changes from what's set out there?
Your Honor, I think let me just confirm this. Of course, the first change is when we had this hearing, but that's a very minor change.
Right.
One of the other changes is we did add a deadline or proposed deadline to have a bid procedures order entered. And I think the other big deadline move is the deadline for the debtor to provide a list of proposed executory contracts to assume and assign, and the cure notice is assigned with that. In the motion, it was proposed as June 1st. It's now being proposed as June 7th. And of course, and then the deadline to object moves commensurate with that move.
So originally, 14-day period.
Yes,
Okay.
Still a 14-day period.
Okay, got it. The first one you mentioned confused me, though. The bid procedures order includes a deadline for entry of the bid procedures order?
Seems a bit circular, doesn't it?
I don't suppose there's anything wrong with that. But
No.
All right.
No.
All right.
We don't need that, I don't think.
All right. I could probably go either way on that.
Yeah. Thanks, Judge. Otherwise, I believe the deadlines are all the same that have been proposed.
Okay, that's helpful clarification. Thank you.
So that's the scheduling, proposed scheduling of the auction and sale hearing, and then the other deadlines. The fifth item is the form and manner of sale, the notice of the sale, auction, and sale hearing. Your Honor, we believe this is reasonably calculated under the circumstances to provide interested parties with notice of these matters. We also believe this is consistent with other transaction or sale notices that have been approved in this district, including in the Briggs and Stratton case. We believe that this allows for adequate opportunity to be heard and participate if parties wish to do so. And then, Your Honor, the final item is the assumption and assignment procedures and then the notice thereof. Again, we believe these are reasonably calculated to provide the interested parties, so the counterparties on the proposed assumed and assigned contracts, that it's going to provide them with notice of these matters, allows for an adequate opportunity for them to be heard and participate so we can work through these issues in a timely manner. We recognize this is a compressed timeline again, but under the circumstances, we do believe this allows for a fair opportunity for folks to participate if they'd like to participate. With that, Your Honor, I'm happy to answer any questions. Actually, I have one more thing. I know there was some confusion on the sale orders that were submitted. One of the items was Exhibit B, the APA, the orders that we submitted had a placeholder for the APA. The APA is unchanged, and we will submit the proposed order with the executed APA. And also, it's worth mentioning that for purposes of sale procedures, we have, or either very likely, or will very shortly, upload a Word version of the APA for folks to mark up if they'd like to become a qualified bidder. But
that'll be in the data room, or yeah, okay,
yeah, that's right.
Gotcha.
And so, with respect to the order, we hadn't included that just for volume's sake, but we will include that for the final proposed order for the court to enter. So,
okay, I think either way is fine. You can include it, or you can call back to, since it's unchanged, you can call back to the version that was attached to the motion if that's simpler. I can't remember whether you're proposing to serve the entire order on a large volume of people. That would be a lot of paper.
Yeah, Your Honor, I don't believe. No, not the entire order. The sale transaction notice.
The notice
would go to everyone.
Yeah.
Yes, and Your Honor, I think to save on paper, we could do a callback, and so instead of having the APA, I think as Exhibit B, we would remove that and then shift everything up. And there was also, I think, some inconsistent references to exhibits. Just for the sake of clarity, Exhibit A is the bid procedures. Exhibit B will now be the sale motion. Exhibit C will be the assumption notice, and we'll just have 3 exhibits, and we'll make sure to correct those internal references accordingly.
All right. I think you said Exhibit B is the sale motion. You mean the sale notice?
I'm sorry, the sale notice.
Yeah,
That's
okay.
right. Yep.
Gotcha. Okay. Okay, that's helpful. We'll be on the lookout for that. All right. Have you concluded the proffer of Mr. Goldblatt?
Yes, Your Honor.
Okay. Would anyone like, now that you know in more detail what Mr. Goldblatt would say if called to testify, would anyone like to cross-examine him? All right, very good. I'll accept the proffer. All right. Would anyone like to be heard on either of the bid procedures motions?
Good morning again, Your Honor. Erin Edelman on behalf of the Stocking Horse Bidder, Allied Medical LLC. Just briefly, Allied Medical is in agreement with debtor's statements made on the record today during debtor's presentation. The APA was heavily negotiated during the pre-petition period and at arm's length, and Allied Medical is supportive of the timeline outlined in the bid procedures motion and proposed order, and also the relief requested therein.
Thank you. Anyone else? All right, Mr. Fairley. I am prepared to grant both of the bid procedures motions. Or I should say grant both of the motions to the extent of the bid procedures related relief requested, and the sale portions of those motions will be heard. As you have requested, June 30th will work. Let's do 9 a.m. on June 30th for the sale hearing. I have a couple of noticing issues to discuss with you. First, let me just make a couple findings. I find that the debtor has shown good cause for the expedited sale process that's requested here. I find that the selection of the stalking horse is a reasonable exercise of the debtor's business judgment, and that the stalking horse protections are reasonable and benefit the estate in the sale process for the reasons explained by Mr. Goldblatt and counsel. My noticing questions and issues really all relate to the contract parties. In my experience, they are the ones who have the most difficulty responding to a change in purchaser, if that should happen here. The notice period tends to be very short. Often they're located in distant locales and don't have counsel admitted here and haven't entered an appearance to see what's going on ECF, that sort of thing. So I'm going to give you a couple comments, and these are based on the New York bid procedures order that was attached to the motion, so not the version that was submitted and uploaded in the last day or so. Now I need to find where that is. It's Exhibit 3 to the New York motion, I believe. So in paragraph 18...
Your Honor, is this
sorry.
Are we looking at the order?
The proposed order attached to the proposed bid procedures order attached to the New York motion.
Yep.
So I'm looking at docket number 25, page 123.
Okay.
You with me? Paragraph 18 has 2 calendar days to file and serve notice of the auction results. Given our time frame, that's a lengthy delay between the conclusion of the auction and the noticing, especially for contracting parties. So, the lender will obviously, lender will be at the auction, lender will know what's going on.
Mm-hmm.
Parties who are paying attention to the case. So, and I think the summary on pages 8 and 9 actually has a tighter, has a 1 day gap there in any event. What I'd like to do, and I want to leave it up to you to work out the details of this, I'd like the notice of the auction result to be filed within 8 hours after the auction concludes.
Okay.
And that would be for both auctions, of course. That anyone who has ECF access will see that. And then I'd like you to come up with a mechanism, and I'm going to give Judge Sanchi credit for this one. He did this in a case I had a few years ago, and I thought it worked very well. On the Stretto website or in the notice or somewhere, just provide a mechanism if you would like to be notified by email of the results of the auction, contact such and such. And then when you file that notice within 8 hours of conclusion of the auction, just email it to anybody who is registered. And that can be, counsel can do it, investment banker can do it, Stretto can do it. I'll let you work out who wants to manage that process. I don't think it'll be burdensome. I don't think there'll be a lot of people who do that. But that way, they'll have time to respond if they have an issue with a new purchaser or adequate assurance issues or those sorts of things. So that would be a change to paragraph 18 of the order, as well as to the notice. So, somewhere in the notice, work in that. If you would like to find out who won the auction, please email this person. Continuing on in that proposed order, page 125, paragraph 23A has the sale notice being served no later than 5 business days after entry of the bid procedures order. Again, that's a very long time period given our compressed schedule. How long do you really need? 1 business day, 2 business days?
I think 1 business day.
1 business day? Okay, let's change that to 1 business day. I know it says as soon as practicable. Don't have any reason to think anybody would sit on it for 5 business days, but I'd be more comfortable with that. And then in the bid procedures themselves, again, looking at New York, page 144 of the motion. Which I think I have here. We've got another 2 calendar days for the notice of auction results, so that'd be another 8-hour deadline, please. And then on the actual notice to contracting parties, I'm now looking at page 151. Let me know if I'm going too fast. I know you've got a volume of documents in front of you.
What are we looking at again?
We're looking at the actual notice to contracting parties. So page 151 of that New York motion.
Yes.
I know the deadline, the June 15th deadline is sort of in the middle of the page. You mentioned that will change.
Yes.
Where I'm getting caught up here is that a counterparty that doesn't object to adequate assurance by, let's say it's June 22nd or something, the bold language below says the successful bidder shall be deemed to have provided adequate assurance of future performance. And the contracting party may not know who the successful bidder is by June 15th or June 22nd or whatever that may be. I believe the order, if I'm reading the order correctly, going back to paragraph 25F of the original proposed order, I believe it provides 5 calendar days for contracting parties to react to adequate assurance in particular if there's a change of buyer. So if we can conform the notice to provide for that 5-day period, I'm fine with the deadline for the stalking horse adequate assurance or anything else about the stalking horse. Everybody knows who the stalking horse is. They're going to provide what they're going to provide. The clock is ticking for contracting parties to object to that. But if we substitute a new buyer, I think we need that at least that 5 days that's provided in the order. So the notice should be conformed to that. And so both this notice and the notice of auction results would need to include a reference to that 5-day deadline. For the notice of auction results, that would be relevant only if it's a different buyer. You don't need to put it in there if the stalking horse wins or if there's no auction at all, of course. If you have a new buyer, that notice should mention you have 5 days to object to adequate assurance or the identity of the buyer or tenant mix, or I don't think that'd be an issue, but whatever else there might be, just specify that 5-day deadline when that goes out. You with me?
Yes.
Okay. And then on page 152, I think we have the same issue. This is, as opposed to adequate assurance, this one is to assumption and assignment more generally, and we have a deadline that may trip somebody up before they even know who the buyer is. So if we make the same change there, I think we'll be good. Those are the only issues I had with the form of order and related notices that were submitted initially. I know a form of order came in within the last few hours. I haven't reviewed that specifically, but I don't anticipate additional issues there.
Understood. Would you like red line copies of these when we submit these, or
I think that would be helpful, and I think probably the lender and the buyer and the U.S. trustee, may want to see a red line as well. I don't know if anybody's going to have any issues, but
Sure.
Everything will move more quickly in terms of the approvals you need from those parties and entry by the court if we have red lines.
all right?
All right, I think that concludes the bid procedures motions. Thank you all. Next, we have the additional motions.
Good morning again, Your Honor. Eric Peterson, Spencer Fain for the debtor in possession. I believe the next item on the calendar this morning is docket number, 32, which is a motion for approval of interim compensation procedures. The debtor filed this motion with its first day motions. It didn't call it up for the first day, bringing it here for the first time today. To streamline compensation for professionals in this case. The streamlined compensation is consistent with local practice and rules, we believe. It would allow professionals, retained professionals, which includes Spencer Fain, to file monthly fee statements and afford an objection period of 10 days. And upon the expiration of that 10 days, the debtor would be authorized to pay 80% of the fees and 100% of the expenses. It's a particularly important feature, I think, for this case because, as you may recall from our discussion on the first day motions regarding the debtor in possession credit facility, there's a budgeted amount for professionals to be paid under the operating budget of the debtor. There is no other form of carve-out or anything to compensate these professionals, and the system is one whereby the lender would put into a segregated account the budgeted amount for fees, and any unexpended fees would go back to the lender. But it does afford some protection against the debtor facing some large bill all at once later in the case after it had been operating, where all the fees come in on the same day. It would be hard for this debtor to manage that. And so we asked for approval of these compensation procedures so that not only could we be paid in real time, but to some degree, but also to, I think, help facilitate the administration of the case as well. All of the fees remain subject to court approval and fee application processes and disgorgement if they are unapproved. So there is no change there, and we will be filing those fee applications for those purposes. And these same compensation procedures would be applicable to any other professionals that we may engage. As the court may see in the near future, we anticipate having employment applications for a New York law firm to assist in this transaction because there's New York property and environmental issues in New York. And we may also have labor counsel to the extent they're necessary to help wade our way through labor issues. And the debtor's historic decades-old corporate counsel, which is Greensfelder, will probably also have an employment application for them. And these same procedures would apply for all of them. As with the other motions in this case, there has been no opposition. Notice has been given of the case, and hard copies have been sent to those who would appear on the top 20 list. We've received no objection or comment, formal or informal. And for that reason, we would ask the court to please approve the interim compensation procedures motion.
Right, Mr. Peterson, as I read the record, the interim compensation motion was noticed on May 25th with an objection deadline of May 30th. Is that Am I reading docket number 89 correctly?
You know, Your Honor, I think you may be correct about that because it wasn't noticed up for first day hearings. It could be that this notice went out later, and so if you'd like to defer it for that reason, that's okay.
I think I would prefer to take this up at the sale hearing or some other date, but since we have a sale hearing, and if you can survive under the local rules provisions between now and then,
Yeah.
I think that would be preferable. So let's renotice this
Okay.
with an objection deadline of, if we're going to June 30th, let's just do June 23rd, a typical 7-day objection deadline.
Okay.
I think it's somewhat unlikely that anyone will object, but I think that way we'll be
understand.
comfortable. Everybody knows what's going on.
Yeah. Okay. Will do, Your Honor. The next motion that is up for today which was not taken up at the first days either, is the Key Employees Retention Program motion. And the debtor filed this with its first day motions, and it's supported by the Akash Amin Declaration. We've been in communication with the U.S. Trustee's Office on this motion as well. And I don't believe there's any objection to it, although Ms. Rischek can correct me if I'm wrong.
Well, Mr. Payson, before we get into the merits, I think we have the same notice issue with this.
We have it.
I think it's on the same notice of hearing with the 5 days to object, and 3 of which were weekend and holidays.
Okay.
I understand there may be sensitivity in terms of timing with the CURP, and so if this needs to be taken up before June 30th, I think we may be able to find a way to do that, but I'm not sure we can take it up today on such short notice, extremely
we'll
short notice.
renotice it, Your Honor, and I'll contact Chambers about a hearing date where we can just come in on that single item.
Okay.
And deal with it that way.
Okay. We'll find a time between now and June 30th that will enable you to get the retentive value if I should approve it, but we'll allow parties a little more opportunity to object.
Great.
So
Thank you, Your Honor. And then there's another motion that's deferred here. This is the KEEP motion, the incentive plan. We're deferring that. We're not even asking to take that one up today. We're continuing discussions with the U.S. Trustee's Office on that motion, so it isn't up at all today.
Okay. Very good.
I believe with those, I think that is the balance of what we have up for hearing today, unless there are questions we can address for the court.
I don't have any questions, and I take it from your comments you don't have anything further. Does anyone else have anything further? All right. Hearing nothing, thank you for your very thorough presentations, and good luck in the sale process.
Great. Thank you, Your Honor.
Thanks, Your Honor.
We'll be adjourned.